Hello friends, in the series on the income tax cases, today we will discuss the case of MALLELIL Industries Private Limited versus Additional Commissioner of Income Tax. This case has been reported in 444 ITR at page number 80 and the matter has been decided by Kerala High Court. The date of the judgment is 15th February 2022. In this case, the moot question before the Kerala High Court was that whether in case of section 263 proceedings where the Commissioner of Income Tax has restored the whole assessment order in entirety to the assessing officer, whether assessing officer can initiate the penalty or not. It is very clear in the Income Tax Act that what the assessing officer can do, Principal Commissioner cannot do. What the Principal Commissioner can do, CIT appeal cannot do. No two persons will enter into the jurisdiction of any person. Meaning thereby that it cannot be said that if any order can be passed by assessing officer, then same order can be passed by the CIT. It is not like that. If the section allows to do so, that can be done. But if the enactment does not allow, that cannot be done. For example, it is the assessing officer power to initiate and levy the penalty. If the assessing officer is satisfied in a particular case that the penalty is to be initiated and imposed, that then he can do so. But Principal Commissioner of Income Tax under section 263 cannot direct the assessing officer that you initiate and impose the penalty. What the Commissioner can do, he can restore the matter under section 263 and direct the assessing officer to pass the fresh assessment order. But he cannot say that you initiate and impose the penalty. Even if in section 263 proceedings, when the whole assessment order is restored in entirety, in that case the assessing officer has the power to initiate and impose the penalty. So in this particular case, the assessing officer imposed the penalty on the assessee by giving him the proper opportunity of being heard. But it was the viewpoint of the assessee that in revision proceedings under section 263, AO cannot impose the penalty. So the assessee was before the ITAT with this ground of appeal that in section 263 proceedings, assessing officer cannot initiate and impose the penalty. But the ITAT held in favor of the revenue and said that the assessing officer was very much in his powers to impose the penalty on the assessee. When the ITAT confirmed the order of assessing officer in section 143 read with 263 and imposed the penalty, so and that order was even upheld by the ITAT. So the assessee was before the High Court with the plea that the order passed by the ITAT is not as per the law. But the Kerala High Court also held that the assessing officer was correct and was well within the powers to initiate and impose the penalty even in the cases of revision under section 263 when the CIT has restored the file to the assessing officer in entirety to make the fresh assessment. Friends, there is value of each and every word in the act. If some power is given to the assessing officer, he can do so. But if any power is not given to the CIT, he cannot do so. So it cannot be said that the post of the CIT appeal is bigger than he can do all the acts. So whatever the power is given by the respective act, that can be only exercised by that respective officer. Friends, this case is very important. It throws the light on section 263, what the AO can do, what the CIT can do. CIT can revise the order under section 263 only on the fulfillment of the two conditions. That is, if the order is erroneous or if the order is prejudicial to the interest to the revenue. Both the conditions should be satisfied. First of all, the order should be erroneous and it should be prejudicial to the interest to the revenue. If any of the condition is missing, then the revision under section 263 cannot be done. But if the order is restored in entirety, the AO gets all the powers which he was having at the original assessment. At the end of this video, once again I am repeating the name of the case. The name of the case is MALLELIL Industries Private Limited versus Additional Commissioner of Income Tax, and this case has been reported in 444 ITR at page number 80, and the date of the judgment is 15th February 2022. Thank you, friends.